High net worth individuals are prime targets for lawsuits, threatening legacies built over generations. What if a U.S. court judgment against you was legally unenforceable? With the right structure, it is. Even if a creditor sues again in that foreign country, they face a nearly impossible standard of proof. And before they can even start, they may have to post a substantial bond, often upwards of $100,000. In the next few minutes, we'll dissect the 5 pillars that make foreign trusts a powerful shield for wealth. A trust is a legal arrangement where you, the settlor, transfer assets to a trustee. You no longer legally own the assets. The trust does, creating the first separation. In the U.S., you generally cannot create a trust to protect your own assets if you are also a beneficiary. Many offshore jurisdictions specifically allow this critical difference. Domestic trusts are vulnerable. The U.S. Constitution means one state court often honors another's judgment. Foreign jurisdictions have no such obligation to U.S. courts. We've established the what and why. Now, let's examine the how. It's about creating a series of obstacles so formidable that most creditors abandon their pursuit. Hurdle 1. A U.S. judgment is just a piece of paper in a country like Nevis. The creditor must hire local lawyers and start a brand new lawsuit from scratch. Hurdle 2. The window to claim a transfer was fraudulent can be as short as 1 to 2 years. By the time a U.S. case ends, the foreign deadline has often expired. Hurdle 3. The standard of proof shifts from more likely than not to beyond a reasonable doubt. Proving criminal-level intent is nearly impossible for a creditor. Hurdle 4. Forcing a creditor to post a bond of $100K or more makes them weigh the cost versus reward. This filters out all but the most determined adversaries. These external barriers are formidable, but the strongest trusts have internal defense mechanisms written into the document. So what happens if the fortress is directly assaulted? An anti-duress clause is a specific instruction to the foreign trustee. It states, if the beneficiary is acting under court-ordered duress, you are forbidden to pay. In a U.S. court, a judge might order you to repatriate assets. You can truthfully say, Your Honor, I've ordered the trustee, but they refused. It is impossible for me to comply. Another defense is the flight clause. This allows the trustee to move the entire trust to a new jurisdiction if threatened, forcing the creditor to restart the entire process. Understanding these mechanisms is one thing. Implementing them correctly is another. Let's address the most common questions, myths, and strategic mistakes. This is a common and dangerous misconception. Asset protection is not tax avoidance. U.S. taxpayers must report all assets and income to the IRS and pay all U.S. taxes. The most critical rule is timing. You cannot build a fortress after the enemy is at the gates. These trusts must be established proactively, long before a lawsuit arises. Do you lose all influence? No. You can be a discretionary beneficiary. You can also appoint a trust protector, a trusted advisor who can oversee and even replace the trustee. We've seen the individual components. Now, how do sophisticated planners combine them? This is where a simple fortress becomes a defense-in-depth system. Recall the core principle. The trust legally owns the assets. It's in a jurisdiction that won't recognize U.S. judgments and has high barriers for new lawsuits. Layer 2, the trust doesn't hold assets directly. Instead, the trust is the sole owner of an offshore LLC. The LLC, in turn, holds the liquid assets. A second legal separation. Here is the master stroke. You, the settlor, can be appointed as the manager of the LLC. This allows you to manage the day-to-day investments, maintaining practical control. If you are under legal threat, you can resign as manager of the LLC. The foreign trustee then steps in, pulling control fully offshore and beyond a U.S. court's reach. The complete picture: a creditor must pierce the LLC, then attack the trust, and do it all in a foreign court with impossible rules and a ticking clock. Foreign trusts are not about secrecy. They are about using different legal systems to your advantage, moving the legal battlefield to a pre-chosen, favorable home court. Recapping the pillars: non-recognition of U.S. judgments, extreme creditor hurdles, internal trust defenses like anti-duress clauses, and multi-layered structuring with LLCs. These international legal frameworks offer a protection for generational wealth that is fundamentally different and stronger than purely domestic options. This is a sophisticated financial and legal tool. It requires careful planning, impeccable execution, and ongoing compliance with all U.S. tax and reporting laws. If you believe your assets warrant this level of protection, the next step is not to act alone. Consult with professionals who specialize in international asset protection. Protecting your wealth secures your family's future, your business's continuity, and your enduring legacy.